best.
Thank you, Senator Booker. Senator Kennedy.
Thank you, Mr. Chairman, and congratulations to all of you. Judge on the far end, tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Okay. Do you know what purposivism is?
In my 12 years as an Assistant Attorney General and my 9 years serving as a judge, I was not faced with that precise question. We are the highest trial court in Washington State, so I'm frequently faced with issues that I'm not familiar with, and I thoroughly review the law, research, and apply the law to the facts presented to me.
Well, you're going to be faced with it if you're confirmed. I can assure you of that. Mr. Berkman, define originalism for me.
Thank you, Senator, for that question. My understanding of originalism.
I'm going to turn your microphone on.
Thank you, Senator, for that question. My understanding of originalism is the notion that the Constitution has an enduring and a fixed nature, an enduring quality and a fixed nature to it.
What does that mean?
It means that the words matter, and that the words that the framers used to draft the Constitution matter, and that it has a fixed quality to it and has an enduring nature.
Well, how do you determine the fixed quality? Who determines what the words mean? From whose perspective?
Senator, in my time as a magistrate judge, I've not dealt with issues of constitutional interpretation, but my understanding is that you would begin with the language of the Constitution itself.
Yeah, okay, I agree with that. All right, anybody want to add? Counselor, Ms. Merchant? I mean, here's what I'm getting at. When you say originalism, the words mean what they mean. From whose perspective?
Thank you for the question, Senator. Similar to my colleagues, I would look to the text in terms of originalism. When you're asking, to the extent that you're asking what I would look to, if so fortunate to be confirmed as a judge, I would look to the precedent, first of the text.
Yes, ma'am, but I'm trying to get you to define originalism for me. What's your understanding of it?
Yes, thank you, Senator. To clarify, my understanding of originalism is similar to that of my colleagues. And in looking at the text and the meaning that was intended in that text, that is the spirit of...
Intended by whom?
By the original writers of that text.
So to you, originalism, you try to interpret what the writers, the authors meant?
In an analysis, a constitutional analysis, it would be the originalism, the text, and the intent of those that drafted the Constitution.
I don't think that's accurate. Does anybody disagree with that? When the Supreme Court says it's following an originalist approach, and in a number of cases, all particularly dealing with Second Amendment, the U.S. Supreme Court has said, on this one, we're all originalists. I think it was Judge Sotomayor who said that, Justice Sotomayor. And on many areas, she's more of a proposivist, but on that she was an originalist. She didn't say we're looking for the meaning that the drafters intended, was she? Anybody want to add to that?
Senator, I'm happy to add to that. My understanding is that...
That's okay. Let me just ask one more. I'm about to run out of time. Judge, on the far end. Can you tell me what the independent state legislature theory is? I'm just asking you, not your opinion of what is it? It's before the Supreme Court now.
In my 12 years as a Washington State Assistant Attorney General, and
Right.
that particular doctrine was not presented to me.
I'm out of time. Thanks, Mr. Chairman. Stan, what I'll refer to as the St. Paul's case, the civil litigation. In the civil litigation, what did the plaintiffs allege?
The plaintiffs allege, Senator, that the school failed to protect Miss Prout from being raped by Owen Labrie. Right. The claims were in negligence and breach of fiduciary duty and Title IX.
And what were the plaintiffs asking for in damages?
They were asking for civil damages in the form of monetary relief, Senator.
How much?
Senator, I can't recall specifically if there was a request made at the onset of the case, and I certainly can't speak to the aspects of the case that involve a confidential settlement.
I'm not asking you about the settlement. I'm asking you about the allegations. Were they in the hundreds of thousands, millions?
I don't recall, Senator, and I don't believe that they necessarily would have had to specify that in the complaint when they filed it.
All right. You were in state or federal court?
This was in federal court in the District of New Hampshire, Senator.
Okay. And at some point, you filed a motion with respect to the naming of the minor. Is that right?
That's correct, Senator.
Tell me about that motion.
The family of the minor.
But tell me about the motion first.
So they filed the motion seeking the protection to proceed anonymously.
Oh, so it was their motion.
That's correct. We had the school had an opportunity through its counsel to respond to that motion, and the school agreed to allow the family to proceed anonymously at all pretrial phases of the case, and asked the judge as a condition of that to require the lawyers to try the case in a court of law and not in the media. We, as the lawyers approached the case, the school's perspective was that the request for the lawyers to try the case in the court of law as opposed to the media was fully compatible with the family's request to proceed anonymously and with privacy.
Okay, so I'm just trying to understand. So the plaintiffs filed in the name of Jane Doe. And then the plaintiffs filed a motion. You didn't file a motion. The plaintiffs filed a motion to continue to ask to continue anonymously. Is that right?
That is correct, Senator.
And then the position of the school, you went to your client, St. Paul's, and said, how do you want to respond? And St. Paul's says, we'll agree to that so long as the plaintiff's lawyers don't try this case in the media. Is that correct?
The position the school took was that they would agree to that provided that the lawyers didn't try the case in the media.
Okay. Was that your position or was it your client's position?
That was the school's position, Senator. I was just an advocate advocating for my client as I had a duty to do.
Okay. So that's what your client told you to file this response. You did. I'm assuming that St. Paul's School was getting the hell kicked out of it in the media. I'm not saying justifiably or not. I'm just stating that as a factual matter. And then what happened?
The judge never got to hear the motion that was filed, Senator, because the family that had filed the lawsuit elected to withdraw the motion before the judge could consider it.
And what was the effect of that?
The effect of that was that the motion that was filed became moot and the judge didn't need to address it and never addressed it. What I can say...
And so the plaintiff continued anonymously?
No, at that point, the family elected to proceed without using pseudonyms, Senator.
So the controversy then is about a motion that the plaintiffs filed that you responded to on behalf of your client, and the motion was never resolved, and the plaintiffs then decided to use real names. Is that right?
I believe that's correct, Senator. Again, my role in the case was as an advocate, advancing.
I get it. That's what I'm getting at. I mean, your job's to protect your client.
I had a duty as an officer of the court to advance my client's interests to the best of my ability, Senator.
What if you'd gone to your client? I'm way over. I'm sorry, Mr. Chairman. This will be my last one. If you'd gone to your client and said, look, well, strike that. I think I understand what happened. Thank you, counsel.
Senator Lee. Senator Blackburn.
Thank you, Mr. Chairman. Mr. Delaney, I want to stay right there with that same
View. Judge Gaston, on December 6th, 2008, you wrote, you talked about this with Senator Graham. I'm going to quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. End quote. Did you write that?
I co-wrote that article, yes, sir.
Okay. When you wrote it, did you believe it?
I did.
Okay. All right, let's start back down on this end. Ms. Almadani, tell me about this doctrine of qualified immunity that we're discussing here in Congress and in the newspapers.
Thank you, Senator Kennedy. Qualified immunity applies in 1983 cases as well as Bivens actions to law enforcement officers.
Right.
Unless there is a clearly established constitutional violation, they are subject to qualified immunity. They are immune.
Okay, thank you for that. Let's go to Judge Hunt. Judge, what is the standard? I'm sorry, I keep bumping my mic. What's the standard for granting a motion for summary judgment in federal court?
Thank you for the question, Senator. Summary judgment motions in federal court are evaluated under Federal Rule of Civil Procedure 56. The question is whether there is a genuine issue of material fact that will require a trial. The moving party has the burden of proof of establishing that there is no genuine issue of material fact and that judgment should be granted as a matter of law. If the moving party does not meet that burden, then summary judgment is denied and the case goes forward to trial.
Okay. So basically it's just, are the facts in dispute and is law in your favor?
That's probably a shorthand for it, but really it's, are there material facts in dispute? Because in my experience, there are often factual disputes, but the question is whether they are material to the resolution of the issue.
Otherwise you wouldn't be in court.
Exactly.
Judge Hugh, tell me about New York Times v. Sullivan.
I believe that was a First Amendment case, Your Honor. I'm sorry, Senator, and about free speech. But in my 5 years of being a judge and 25 years of practice, I haven't had to actually apply New York Times v. Sullivan.
Okay. Judge, well, I talked to Judge Cummings.
Good afternoon,
Good
Senator.
afternoon to you, sir. Tell me the rule that the United States Supreme Court follows in deciding whether to overturn precedent.
Thank you for that question, Senator.
You're welcome.
In deciding to overturn precedent, the court looks at a number of factors, including the soundness of the reasoning of the decision in question, the workability of the rule that it establishes in terms of how it is applied, developments that have taken place since the decision was issued, and they also look at reliance that parties or litigants have placed upon that decision in question.
Okay. Let me ask you, well, I'll start back here again. What did the White House give you to prepare for today's hearing?
Senator, there were a number of meetings with the White House counsel's office.
Did they give you any written materials to read?
There were some written materials.
Tell me, what were those?
There were materials that were already in the record, questions and answers from prior hearings.
So they gave you a list of questions and answers from prior hearings?
An overview, I would say.
Yeah. How many questions and answers did they give you?
I'm not sure, Senator. Sitting here, I'm not sure exactly how many questions.
Was it more than 10?
Yes.
More than 50?
I don't believe so.
Okay. And whose questions were they?
They were Senator's questions.
Which ones?
There were some of your questions, Senator.
Were there?
But I also watched many hearings, and so I'm.
Thank you, Mr. Chairman.
That's a tribute to you, Senator.
I'm smiling. Thank you, Mr. Chairman. Judge, Counselor, congratulations. I want to be sure I understand your records. We'll start with Judge Cruz. Judge Cruz, you handled a case called ViaNet Operating Group v. Maurice. Is that right?
That's correct, Senator.
And you were reversed in that case. Is that right?
Yes, Senator.
You handled a case called Moodin v. University of Colorado. Is that right?
I believe so, Senator, yes.
And you were reversed in that case, right?
I believe a portion of my recommendation was reversed, yes.
Okay. Did you handle a case called Vreeland v. Vigil?
Yes, Senator.
And you were reversed in that case too?
A portion of that was reversed as well, yes.
Okay. Did you handle a case called Vreeland v. Olson?
Yes, Senator.
And were you reversed in that case too?
A portion of that was reversed as well, yes.
Okay. You handled a case called Key Bank National Association v. Williams. Is that right?
Yes, Senator.
Were you reversed in that case?
Senator, I've issued over 1,500 recommendations and orders over the course of my 4 years on the bench, and that is one that was partially reversed, yes.
Okay. You handled a case called Renault v. Cardenas. Do you remember that case?
Yes, Senator.
And you were reversed in that case too?
A portion of that was reversed as well.
Do you remember a case called Janney v. Gomez?
Yes, Senator.
And were you reversed in that case?
A portion of that was reversed as well, Senator.
Okay. How about a case, do you remember this case, Judge? Schwartz v. City of Denver?
The name is familiar, Senator. For all the cases I've handled, I'm not recalling particulars about that case.
Okay. Do you remember being reversed in that case?
Senator, I'm not specifically recalling that case.
Okay. Do you remember a case called Lucas v. Board of Commissioners of Larimer County?
The name is familiar, Senator. The details of the case are not coming to hand at the moment.
Do you remember being reversed in that case?
Senator, I don't recall offhand at the moment with that case.
Do you remember a case called Brooks v. Colorado Department of Corrections?
Yes, Senator.
Were you reversed in that case?
I'm not recalling offhand if that was one where I had a partial reversal.
Okay. Do you remember a case called ACV, Jefferson County School District?
Yes, Senator.
Were you reversed in that case?
I was partially reversed in that case as well.
Okay. You remember a case called Blake v. United States?
The name sounds familiar, Senator.
Okay. Do you remember being reversed in that case?
I don't specifically recall that particular case.
Okay. Well, I've got others here. Cases that you handled in which you were reversed. Tell me why you've been reversed so often, Judge.
Well, Senator, as I indicated, I've issued over 1,500 recommendations and orders over the course of my career. When I approach any of these cases, I approach them all in the same fashion, which is to analyze the law, analyze the Supreme Court and 10th Circuit precedent that bears on those cases, and I apply those cases to the law or to the facts of that case. As a magistrate judge, many of those are recommendations that are made which are reviewed de novo. I respect the decisions of those district judges who viewed those circumstances differently.
Okay. Thank you, Judge. Tell me how you analyze a Brady motion.
How I analyze a Brady motion?
Yes.
Senator, in my 4.5 years on the bench, don't believe I've had the occasion to address a Brady motion in my career.
Do you know what a Brady motion is?
Senator, in my time on the bench, I've not had occasion to address that, and so it's not coming to mind at the moment what a Brady motion is.
Do you recall the U.S. Supreme Court case, Brady v. Maryland?
I do recall the name of the case, Senator, yes.
And what did it hold?
I believe that the Brady case, Senator, I believe the Brady case involves something regarding the Second Amendment. It is not. I've not had occasion to address that. If that issue were to come before me, I would certainly analyze that Supreme Court precedent and apply it as I would need to the facts in front of me.
Thank you, Mr. Chairman.
Thank you, Senator Kennedy. We'll give Senator Tillis a moment to settle in. He'll be right.
Thanks, Senator Fetterman. Senator Kennedy of Louisiana is recognized.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here. Mr. Weggio, am I saying your name right, sir?
It's Weggio, Senator.
Weggio, thank you. You've been nominated for Assistant Secretary of Fair Housing and Equal Opportunity at HUD. Is that correct?
Yes, Senator, that is correct.
Tell me the difference between Title VII of the Civil Rights Act of 1964 and the Fair Housing Act.
Certainly, Senator. My understanding is that Title VII of the Civil Rights Act deals principally with labor practices and employment practices, whereas the Fair Housing Act is principally focused on discrimination in housing, sir.
Okay. Is there a difference in the protected classes in the two statutes?
Thank you, Senator. I don't have a ton of experience with Title VII. I will say that the protected classes under the Fair Housing Act are well established as race, national origin, religion, familial status. I can name the rest if you'd like, Senator.
Okay. Tell me about Bostock v. Clayton County, the Supreme Court case.
Yes, Senator. So my understanding about Bostock was that it interpreted specifically the protected class in the Fair Housing Act dealing with sex and gender to include LGBTQIA individuals for those protections, and that was...
Excuse me if you're interrupting, but was Bostock an employment case or a housing case?
Senator, thanks for the question. I actually don't know the answer to that, Senator.
Well, it's kind of fundamental. I mean, what was the holding of Bostock?
My sense was that Bostock, as it's been interpreted by HUD, it made
I'm not
sure
asking how HUD interpreted it. I mean, you've read the opinion. What does it say?
Sure.
It's an employment case, right?
My sense, Senator, I get what you're getting at with this questioning.
What am I getting at?
My sense is that this was a case. Well, I'm not a lawyer, Senator, and I have not had a good deal of experience with labor law. But the position I've been nominated for deals with.
Well, let me tell you what I'm getting at. Okay, Bostock dealt with employment discrimination. Okay, its holding doesn't have to do with housing. Do you propose that the holding of Bostock be extended to housing?
Senator, my understanding is that HUD issued an interpretive rule.
I'm not asking about HUD. I know what HUD's done. I'm asking about you. Bostock, you say you've read it, and I believe you. If you have, you know it's an employment discrimination case, right?
Yes, Senator.
Okay. Do you think that the holding of Bostock can fairly be extended to the field of housing?
Senator, my view is that the role for which I've been nominated is to faithfully enforce the laws as Congress has written them and as they have been interpreted by the courts.
I'm asking you what the law is. I'm asking you what Bostock held, and do you think that Bostock can be extended to housing?
Senator, and I apologize if I'm missing the mark on your question. My sense is that Bostock held that the sex-prohibited basis or protected class under that set of laws under Title VII did include individuals who identify as LGBTQIA.
Well, here's what I'm getting at. Bostock was an employment discrimination case. All you got to do is read it. There it is, big as Dallas, okay? And HUD has said we're going to apply Bostock to housing. Not employment discrimination, to housing. And you're going to have to go along with that. Otherwise, you're not going to last very long on your job. So legally, how can that be done?
So, Senator, I don't presently work at HUD. I am familiar with the interpretive rule you've described.
I don't think you're going to answer me, and I'm going to run out of time. Thank you, Mr. Chairman. Congratulations, gentlemen. Mr. Papillon, tell me the definition of a motion in limine.
Motion in limine, in some law books it doesn't exist, Senator, but what it is it is a motion filed in advance of trial to get a ruling in limine, which means in advance of some issue that may come up in the trial, usually an evidentiary issue.
I thought you might know.
Thank you.
Judge Herson, explain to me the various definitions that the U.S. Supreme Court has used to define a fundamental right.
In Glucksberg, and even recently in Dobbs, the Supreme Court has really focused on two major issues. One, whether the right in question is deeply rooted in our history and tradition. And the court is also focused on whether it is implicit in the concept of ordered liberty. And I also believe that in Glucksberg they describe the need for the right to be clearly defined.
How does that relate to the discussion in Griswold of a penumbra?
Well, obviously, Griswold, as you state, points out this concept of the penumbra, rights that are not explicitly enumerated, but that the court has otherwise found. As a sitting magistrate judge, and if I was fortunate to become a district judge, I would, of course, follow the guidance of the Supreme Court, who has identified just a few, relatively small number of those rights. Obviously, the right to privacy, perhaps being the most well-known.
Well, can you have, what has the Supreme Court said about the existence of a fundamental right that is not part of our history and tradition? For example, when the court delved into the Second Amendment, it was really, the opinions were almost written as if they were historians as opposed to judges, but part of our history and tradition was a fundamental part of their discussion. Does the right have to be part of our history and tradition to be fundamental?
Well, I can say this, that in Heller, McDonald, and Bruin, that was the focus. That's what the court looked at. Now, there are other cases throughout history that have recognized a few other rights, the right to marry, for example. And I can't speak to the specific methodology that was used, but I will say, at least in the Second Amendment context, that focus on history was critically important.
Okay. All right. Let me move to Mr. Daniel. Can a police officer well, let me try this another way. If I'm walking down the street and a police officer wants to stop and talk to me, can he just stop and talk to me for any reason?
Senator, you can seek your consent to stop and talk to you.
What if I don't consent?
If you don't consent, then the officer needs to have a reasonable articulable suspicion that a crime has been committed, will be committed, and be able to articulate that to justify the stop.
Okay. Then how come police officers can set up a roadblock and stop 500 people to see if they have liability insurance?
My understanding is that the Supreme Court has ruled that those types of stops, when generally applied, are conducive to good order and policing.
Why? They're still stops, aren't they?
Senator, in my 8.5 years as a prosecutor, I've not had to litigate the adequacy.
I know. I'm just asking you what you think. I mean, isn't that pretty intrusive? What if I'm in a hurry to pick up my kid from school and I don't have time to wait for 10 minutes? And I don't want to wait anyway. Why? If a cop can't just stop me on the street, why can they stop me and check my insurance?
Senator, as far as my personal belief, I haven't encountered that.
I'm just asking you legally, why can they do that?
Again, I haven't encountered that issue, so I don't have the research on that, Senator.
Okay. Thank you. Thank you, gentlemen.
Senator Welch? Thank you, Senator Cotton. Senator Kennedy?
Thank you, Mr. Chairman, Judge D'Alba, Judge Ramirez. Congratulations to you both. Judge D'Alba, do you think, I want to wax a little philosophical here, do you think a person's race should be used to harm that person?
No, Senator.
How about you, Judge Ramirez?
No, Senator.
Okay. Judge D'Alba, do you think that a person's race should be used to help that person?
No, Senator.
Okay. How about you, Judge?
No, Senator.
Okay. Judge D'Alba, why is that?
Well, as a legal standard, Senator, we try to look at people just based on either, if we're in a criminal position, we're looking at them for what they've done. In a civil matter, it usually doesn't come into account. So, and also it's something they don't necessarily control, so it seems unfair.
Okay. Judge Ramirez?
The Constitution provides for equal protection for all.
Okay. Judge D'Alba, this has been in the news a lot lately, and you'll probably see it if you're confirmed to the Court of Appeal. Tell me about the Dormant Commerce Clause.
Senator, I'm somewhat familiar with the Commerce Clause, which is found in Article 1 of the Constitution.
It was a big Supreme Court case that just came out of your state.
And I apologize, Senator. In my 11 years of practice and my 5 years on the bench, I have not dealt with the dormant Commerce Clause, but if I am so fortunate enough to be confirmed and have to deal with it in the future, I would certainly research it and, be prepared.
All right, then just tell me about the Commerce Clause in general.
So my understanding about the Commerce Clause, like I stated, Senator, is that it is under the Article 1 of the Constitution, and it allows the legislature to create laws that allow for movement and things related to commerce in the United States. So anything crossing state lines, things like that.
So it allows Congress to regulate commerce.
Yes.
Between whom?
Between states, for example?
Mm-hmm.
Yes.
Anybody else?
It's not coming to mind right now, Senator.
Okay. All right. You're familiar, Judge, I'm sure, with the Fourth Amendment and the warrant requirement. What's, just for the record, what's the warrant requirement?
The warrant requirement requires, so Fourth Amendment says that we are not subject to unreasonable searches and seizures. So in order for someone to, for example, enter our home, there needs to be a warrant. And in order to get a warrant, an officer has to, under oath, state that there is probable cause to believe that either a crime has been committed or there is a crime afoot, and that they have to describe with particularity the place to be searched.
And that's based on the Supreme Court's interpretation of the U.S. Constitution, correct?
Yes.
Okay. Let's suppose that Florida passed a law and said, we don't agree with the Supreme Court's interpretation of the Constitution and the Fourth Amendment and the warrant requirement. We're really concerned about the power of the state. And we're going to ignore the warrant requirement that no police officer has the right to come in your home, probable cause or otherwise, unless you agree to it. Would that be legal?
Well, Senator, I'd have to, it's somewhat of a hypothetical question, but I would
have. It's a very real question. Happened before. Would that be legal?
I would have to look at it a little bit more carefully, but, you know, on first blush, my concern would be that under the Article 6, the U.S. Constitution is the supreme law of the land.
Yeah.
So we have to follow it.
What if Florida said under the state constitution, we're doing this? Does the U.S. Constitution always, or the Supreme Court's interpretation of the U.S. Constitution always prime a state constitution?
I have not dealt with that issue in...
Well, there's a big case out of your state that deals with this issue. You familiar with the Pruneyard case?
The Pruneyard case I am familiar with.
Tell me the holding of that.
The holding of that was, it had to do with individuals who wanted to...
yeah, but just tell me the holding. I remember the facts. Tell me the holding.
The holding was that the takings clause didn't apply to individuals outside of a shopping center who wanted to protest or because...
Yeah, but the point I'm trying to make is that the U.S. Supreme Court in that case said that the California Constitution primes the federal Constitution, didn't it? Isn't that what it said?
Yes, Senator.
So you want to go back to your answer about the Florida hypothetical I gave you?
As I stated, Senator, if I had a little more time to look at it and really think about it, I would be able to come up with something.
Thank you, Judge. Judge Alicon, am I saying that right?
Yes, Senator.
Okay. Will you allow your personal or political beliefs to affect your decisions?
No, Senator. My personal beliefs have never played a role in the positions I took as an advocate, nor do they play a role in the positions I take as a judge when I'm neutrally deciding a case.
Okay, I'm glad we got that off the table. Let me ask you a few questions about how you view the world. Do you believe that minorities need special help to succeed?
Senator, that issue is currently pending before the U.S. Supreme Court.
Yes, ma'am, but we just established that you're not going to let your personal opinions affect your decisions. You're going to follow precedent.
Absolutely, I will follow whatever
Okay.
precedent comes
So let's
from the
talk
Supreme
about your
Court.
personal opinions, which will be irrelevant to your position on the court. Do you believe that minorities need special help to succeed?
Senator, again, I don't have a personal position, and sitting here as a current sitting judge and
Have you
as
thought
a
about
nominee,
that? Have you thought about that?
I am aware that we have given preferential treatment. It's been subject to a lot of different court cases. The
Okay,
issue.
do you agree with that or disagree with it?
It's not a question, Senator, of whether I agree or disagree. I
Sure
apply
it
the
is.
law
You're-
as it comes before me.
You're being confirmed to the federal bench, and presumably you're a critically thinking person. I'm just asking you what you believe. Let me ask you one more time. Do you believe that minorities in America need special help to succeed? It's a very simple question.
Senator, to the extent policymakers have enacted laws that provide protections,
Do
I
you
would
agree with
faithfully-
those policymakers?
I am not a policymaker, and as a sitting judge, it is.
You don't have an opinion, or you're just not going to answer. I don't want to waste more time if you're not going to answer.
Senator, as a sitting judge, it is inappropriate for me to
No, it's
comment
not.
on my personal
No, it's
views.
not. We've already established that you're not going to let your personal beliefs interfere with your decisions, so I think you ought to tell us what your personal beliefs are. Do you believe in systemic racism?
Senator, again, that's a question for sociologists and academics. I take
You
every
don't
case.
have an opinion. You never thought about it.
I take each case as it comes before me on the individual facts.
What is systemic racism?
My understanding is that it's a sociological theory that racism plays a systemic role. But beyond that, I'm not an academic. I'm not a sociologist. I am a judge, and I apply the facts and the law to the cases that come before me.
Right, but you don't have an opinion.
No, Senator, I do not.
Do you have an opinion on anything you'd like to share with us?
Senator, as a sitting judge, it's inappropriate for me to comment on any personal views I might
No, it's
hold
not.
because
We
I
just
would not.
established the first question I asked you was, your view of the world does matter. If you never thought about the world, if you never thought about these issues, you're not qualified to be a federal judge. And I think you ought to come here and answer. I think all of you should come here and answer them forthrightly. If I ask you, let me ask you one last question, and I will quickly, Mr. Chairman. Do you believe you sit on the District of Columbia Court of Appeals? Is the District of Columbia Court of Appeals systemically racist?
Senator, as a sitting judge, I think it would be inappropriate for me to comment. I can say all of my colleagues take the cases open-mindedly
But do
and
you
on the
think it's
facts before them.
systemically racist?
I don't think that it is, Senator, but I also
Okay.
don't know if I'm qualified to give that type of assessment.
Well, you sit on the court, right?
I think all of my colleagues take their cases with an open mind, without any prejudice, and faithfully apply the law to the
Well, I'm
facts.
disappointed you won't answer my questions, but I thank the chairman for giving me the extra time.
Thank you, Senator Kennedy. Senator Hirono?
Mr. Chairman, and congratulations to all of you. Mr. Clerk, do you believe in stare decisis?
Absolutely.
Tell me what that is.
Is to follow precedent.
Okay. If you're confirmed, will you follow all higher court precedent?
Yes. I pledge to this committee that if I am confirmed, I would follow all Supreme Court, Sixth Circuit precedent.
Okay. Would you have followed the Dred Scott case?
Boy, there are some foundational cases where there
Yes, ma'am.
is-
Let's just start out with the basics.
Sure.
If we could. Would you have followed the Dred Scott case?
As a federal lower court judge, I would have been obligated to follow that case
So
as
you
precedent.
You would have.
If I had been a lower federal court judge, I would have been obligated to do so unless the...
That's a yes. There are only
there-
two doors here, yes or
Yes.
no?
If I had been a judge at that time, I would have been obligated to do so, yes.
Okay. Would you have followed Plessy v. Ferguson?
Again, your Senator, as a lower court federal judge, if I were to be confirmed as a district court judge, I would be obligated to follow all the Supreme Court precedent. If the Supreme Court determined that there was a precedent that it found that it should overrule, they have that opportunity to do so, but as a lower court judge, I would be obligated to follow it.
That's a yes?
Correct. Correct.
Okay. That was nice of Tom. Thank you, Tom. I'm going to send you a fruit basket. Give me that sheet back. Judge Oliver, how flexible must an employer be when a worker asks for a religious accommodation? What's federal law on that?
Senator, in my 14 years as a state court judge and 11 years as a litigator, I haven't had that issue presented to me. I can commit to this committee that if presented with this issue, I'll research it well and be prepared to address it in advance of the proceedings.
So you're not familiar with the Supreme Court precedent on religious accommodation by an employer?
I'm not sufficiently versed on it to be able to answer it appropriately, Senator.
Okay. Tell me about the political question doctrine.
Yes, Senator, thank you for the opportunity. The political question doctrine is the one means by which the United States Supreme Court can decline to act. It indicates that when an issue is before the court that's so inherently political and it's in the process of being considered, that the Supreme Court can decline to act and leave it to the appropriate body.
Okay. Give me an example, if you would, please, Judge.
An example of a political question.
Let me ask you, in preparing for the day today, you met with the White House counsel?
Yes, Senator.
And their team? They got a good team, don't they?
Yes, Senator.
Did they give you a list of questions to be prepared for?
A list of some questions, Senator, yes.
How many questions were on there?
How many questions? A few dozen, I would suggest. I would estimate.
Just a few dozen?
Yes, Senator. I think that's accurate.
Okay. And where did they get these questions?
Some were taken from prior public hearings before this body.
My questions?
Yours are on that list, Senator, yes.
Okay. Thank you, Mr. Chairman.
The Kennedy bar exam lives on. Senator Lee.
Thank you very much, Mr. Chairman. Thanks to all of you for being here. Judge Ali Khan, I'd like to start with you.
Heal our relationship, Brother Kennedy and I, and I'm hoping that your wisdom will inform probably some really strong actions. Thank you, sir. And Mr. Chairman, thank you for the time.
Thanks, Senator Booker. Senator Kennedy.
I didn't know he was going to get a rebuttal so quickly.
That Senator Booker has a silver tongue, doesn't he? He's good. I know Mr. Long and I know Mr. Edwards. I don't know Mr. Haji or Judge Maddox. Congratulations to all four of you, though. Judge Maddox, I think I'll start with you. I just want to talk about the law a little bit. I stipulate that you will follow the law and apply it to the facts of the case as you are guided, including but not limited to precedent. I thought the Supreme Court just handed down some really interesting decisions. One of them has not been talked about much, but I found it fascinating. Tell me about Moore v. Harper. That was the the independent state legislature theory. What's that all about?
Good morning, Senator.
Good morning.
Yes, Moore v. Harper concerned whether or not the Elections Clause in Article 1 of the Constitution gave the state legislature sole authority to regulate elections for federal office in their states without any judicial oversight. And the Supreme Court held that the Elections Clause did not preclude judicial oversight of the legislature's regulation of federal elections.
I can tell you looked at the case. Here's one way of looking at it. Every state has a state constitution. And I want you to tell me if you think I'm wrong here. Every state has a state constitution. And in fact, many state constitutions preceded the federal constitution. And some of the provisions in our federal constitution were copied directly from state constitutions. And as I read Moore v. Harper, what the Supreme Court is saying to a state legislature is, look, yes, Congress gave you the power to draw congressional districts, but you've got to do it consistent with your state constitution. And so the state courts get to weigh in. And if the state courts don't render opinions that are consistent with the federal constitution, then the federal courts get to weigh in. What do you think?
I believe that that's a fair reading of, or maybe perhaps reading between the lines of that opinion. That particular question is not one that I'd considered previously, although I have reviewed that opinion.
Yeah, I just found the whole case very interesting because the theory of the plaintiffs was that state legislatures can do anything they want to do with respect to congressional reapportionment because Congress gave them power. But it ignored the role of the federal judiciary and the state constitutions, which, anyway. Mr. Haji, tell me about, I need to get a life, I guess. Mr. Haji, tell me about this waters of the United States controversy. What's it all really about?
Senator, I'm not, I've been an attorney for 12 years with the Navy, and I've practiced in government contract law for a long time, and I've worked on those kinds of issues for the last almost 12 years. I haven't encountered that particular issue that you're referencing.
Okay. All right. Tell me, this will be my last question. Tell me, doesn't strict liability seem inherently unfair to you?
So my understanding of strict liability, Senator, is that there's limited circumstances for when it's applied, and my
Like
job.
What? Like what?
Excuse me?
Give me some examples.
Like in product liability case,
Yeah.
for example. And I think the idea of strict liability is under those limited circumstances to encourage the right sort of behavior for, let's say, a product manufacturer to not create a product that's going to kill a baby, for example, that severe consequences have to ensue.
Well, I'm not saying I disagree with you, but tell me, how does it comport with due process? I mean, this is basically, some would argue, this is basically a legislature saying, hey, if you do it, you're automatically liable. You don't get due process. You don't get to defend yourself. There are no defenses. What do you think about that?
Well, my understanding is that strict liability comports with due process because you have the right to be heard in court. And it's, I think, a good example of the balancing of the branches of government from that perspective, because it, like you said, takes Congress's perspective into consideration as well.
Thank you, gentlemen. Thank you, Mr. Chairman.
Thanks, Senator Kennedy.
Senator Kennedy. Thank you, Mr. Chairman. Congratulations to all of the nominees. Judge Mahalchek, you remember a case called Yentzer v. Potter County?
I have a recollection that I presided over that case. I don't know if I recall the details of it.
Okay. And you were reversed, is that right?
I believe that was a case that I issued. I was a magistrate judge in that role and in the referral role on it, and it was reviewed by the district court, yes.
And you were reversed, right?
I don't recall in that case if the report and recommendation was adopted in full or not adopted in full, but yes.
The higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Do you remember a case called Myers v. Clinton County Correctional Facility?
I recall that case as well.
And you were reversed in that case too, weren't you?
I believe it was adopted in part, yes.
Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
I believe that R&R was not adopted in full, correct? Yes.
Okay, but you were reversed.
It was not adopted, yes,
Is that
by
the
the
same
district
thing
court.
as being reversed?
It's a different. The district court declined to adopt the report and
The higher
recommendation.
court
in
said
full.
you were wrong.
The district court disagreed with my report. Yes.
Yeah, okay. Do you remember a case called Shania v. East Pennsboro?
Yeah, the Chanias are pro se plaintiffs who have brought a number of cases, so I'm not sure which one you're referring to. But yes.
I'm just curious, you were reversed in that case too, were you not?
In part, yes.
Okay. Do you remember a case called Spanier v. Libby?
Yes, I do.
The president of Pennsylvania State University was convicted of covering up child sex abuse crimes. And you let him go on a habeas corpus petition. And the Third Circuit reversed you, is that right?
I directed that a new trial should be held with a different jury instruction, and the Third Circuit disagreed and found that he had received the due process he was entitled to, yes.
Well, the Third Circuit said you failed to cite, analyze, or properly apply the relevant case law. You were reversed, right?
The Third Circuit reversed my decision, yes.
Okay. Do you remember a case called Hassel v. Centric Bank?
I vaguely recall that case, yes, Senator.
You were reversed, weren't you?
I believe the district court failed to declined to adopt my recommendation, yes.
Do you remember a case called Ramsey v. Amtrak?
Yes, I do.
And the higher court reversed you in that case too, didn't they?
The district court concluded that I was correct in finding that the petitioner did not pay a filing fee, and where I had recommended that the case be dismissed, he granted the petitioner 30 days to correct that.
So you were reversed in part?
Yes.
Okay. Do you remember a case called McCracken v. Fulton County?
Yes, I do.
You were reversed in that case too, weren't you?
I believe that was in part, yes.
You remember a case called Bird v. Britton?
I do.
And were you reversed in that case?
In part, yes.
Okay. You remember I'm sorry. You remember a case called Allen v. Lackawanna County Board of Commissioners?
I believe I recall that case, Senator.
And you were reversed in that case too, weren't you?
I believe I was reversed in part in that case, yes.
You remember a case called Daniels v. Capital One Bank?
Yes.
And I believe you were reversed in that case too?
I believe it was, yes, I believe so.
Do you remember a case called Downey v. Pennsylvania Department of Corrections?
Yes, I recall that case.
And were you reversed in that case?
Yes, I believe I was.
Remember a case called Rejean v. Wetzel?
I vaguely recall that case, yes, sir.
And were you reversed by our court there too?
I believe that our report and recommendation was not adopted in full.
Okay. I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
No, I have not, sir.
Well, your nomination was talked about, and Senator Toomey refused to send in a blue slip for you, did he not?
I'm not sure exactly what happened. I know that this process has been ongoing for 2 years.
Yeah, but you know that Senator Toomey refused to even, thought you were so unqualified that he refused to even allow the Judiciary Committee to consider you. Isn't that correct?
I do not know what Senator Toomey's reasons were. So
You've never talked to Senator Toomey about it?
I never discussed it with Senator
And
Toomey.
you don't
no.
know anything about a blue slip being withheld on you?
I do not know.
You're under oath.
I am under oath, and I know I did not speak with Senator Toomey about his reasons for not.
Was Senator Toomey's concern that you were unqualified?
Again, Senator, I did not speak with Senator Toomey or his staff about his reasons for not supporting me.
Okay. Thank you, Mr. Chairman. Judge, our second judge, will you allow your personal beliefs to interfere with your judgment on the bench?
No, Senator.
And do you have personal beliefs?
Yes, Senator.
I'm glad to hear that both of you have personal beliefs. You've thought about the world. Judge, do you think minorities need special help to achieve?
Senator, I think as a country, we have come a long way. There are certain issues that the Supreme Court just decided last term on a case of affirmative action that dealt with this issue.
Yes, sir, I'm familiar with the case. Do you believe that minorities in America need special help to succeed?
Senator, I think all people should deserve equal opportunity to succeed.
Okay. Do you believe minorities need special help to succeed?
Senator, again, I think based upon a person's background and their community they come from and what hardships they face, I hope that all persons in this country who work hard have an opportunity to succeed.
Let me try it again. Do you believe that minorities in America today need special help to achieve, to succeed?
Yeah, again, Senator, from all persons, no matter what community they come from.
Yes, sir, but do you understand the question? Am I not being clear?
No, I understand, yes, sir.
Okay, would you answer it for me, please, sir?
Well, Senator, I'm stating again.
So yes or no, it's pretty simple.
Well, I believe that is a complex question in many ways that it's difficult to answer yes or no. Again, I believe all persons.
I don't understand why. You either believe that minorities need special help to succeed or you don't. Is there a reason you won't answer my question?
Well, Senator, again, my answer is persons from all communities. I would also note, of course, there are certain issues when you say minorities.
You're not going to answer it, are you?
Well, like race, that has been
Okay, let's move on. I think by not answering it, you have answered it, but can you tell me what you think about the Navy, whether it's systemically racist?
Senator, the Navy I know is not, and in fact, its primary focus is to be the most lethal maritime fighting force in the world.
Okay, thank you for a straightforward answer.
Senator Klobuchar, Senator Kennedy.
Judge Lee, I don't believe you were truthful in answering Senator Lee's questions. You wrote an article in 2010 entitled An Overview of Special Populations in California Prisons, did you not?
Yes, I did.
Okay. And in that article, you argued that male prisoners should be allowed to claim they are transgender in order to be assigned to a female prison, didn't you?
As I said to Senator Lee, that was an article which arose from a symposium, which I just moderated the panel, and then summarized for the symposium edition the different arguments and issues that were raised.
Well, I've read your article, and I don't think that's accurate. You identify certain special populations, transgender people, immigrants, and racial minorities. And you're very critical of the way the California prison system treats them. For example, I'm going to quote here, your words, not mine. The prison system relies heavily on a dichotomous sex-based means of classification. Prisoners are classified by their biological attributes rather than their gender identification. As described by one of the people in the California prison system, The classification process is gender neutral. We really don't distinguish between transgender and non-transgender inmates. Did I read that correctly?
Senator, I don't recall it word by word, but
Here it
think
is.
So, okay.
And at the end, here's your conclusion. Your words, not mine. In conclusion, because each of these populations, including transgender, traditionally has been marginalized by American society based on their gender, race, ethnicity, or status, they are often further distanced from and marginalized by society upon incarceration. A recent president said you can fairly judge the character of a society by how it treats the weak, the vulnerable, the most easily forgotten. Did you say that?
That's what was written.
Okay. And so, but you're saying your article is just a summary of the opinions of people that you moderated?
I moderated a panel. There were 3 panelists about those different topics. That's what was represented in terms of the issues. And
well, let me just ask you, do you think that a male prisoner convicted in a court of law on final judgment should be allowed to claim that he is transgender in order to be assigned to a female prison?
Senator, as discussed earlier, the issue of assignment in facilities and such as one which is being actively litigated in California and may become before me. If I were to be
now all of a
confirmed,
sudden you can't answer it. You answered it in your law review article.
Senator,
you were for it. But now you can't answer it? Is that your testimony?
My testimony is that was an article from over 13 years ago, and that as a judge now, and as I have been for nearly the last 5 years, my responsibilities are to fully, faithfully, and
the truth is you believe that a male prisoner should be able to allow at the sentencing phase to claim that he is transgender in order to be assigned to a female prison. Now, you believe that, don't you?
Senator.
You wrote it.
Again, that was a piece which summarized and came out of a symposium edition about the California prison crisis generally.
You found it at Georgetown, the Georgetown Journal of Gender and Sexuality Law Journal, did you not?
At Georgetown, I was one of the founding members. I didn't, of the...
Did you found it? Did you help found it?
I was one of the initial founding group members.
All right, and one of the first articles was entitled, that you picked was entitled, quote, "The Politics of Eradication and Future of LGBT Rights." And in that article, you accused Republicans, or the article you chose, accused Republicans of being influenced by, quote, "a desire to eradicate LGBT identities." Is that accurate?
Senator, I was an articles editor in the first edition.
You don't remember that article?
I do not recall. I do not know whether or not I edited that.
Okay, well, here's another article you picked. Quote, here's the title of the article that you picked for your journal. "Gender is fake. The ongoing need for an equal rights amendment." And the article says, quote, "The need for the ERA is more pressing now than ever, given modern conceptions of gender as a social construct." Did I read that right?
Senator, I don't, as I said, I was an articles editor who edited.
Senator Durbin may save you here, but I don't think you've been honest with this committee, because I've read your writings. And I'd respect you a lot more if you stepped up to the plate and said, "This is what I believe."
I might say to the Senator from Louisiana, my goal is to run the committee and not salvation. I believe the judge can speak for herself.
I'm sure well, let me say this. Thank you for giving me the extra time.
Judge Padilla.
Thank you, Mr. Chair.
Senator Padilla.
I've been called worse. I do have a question asked the first panel that I intend to ask the second panel, but given the issues and, if I can use air quotes, concerns raised by some of my colleagues, let me try to address the topic at hand. As some of my Republican colleagues have mentioned before.
Senator Kennedy?
Thank you, Mr. Chairman. Judge Kohler, am I saying your name right?
Yes, Senator.
Okay. Will you allow your personal beliefs to affect your judgment on the bench?
No, Senator.
Okay. Do you have personal beliefs?
Senator, I have personal beliefs like anyone, and I certainly understand the issues that the country is facing. I try very hard because of the fact that both as a reservist and as a sitting federal judge, I have to act within a chain of command, and specifically as a judge, only decide issues after I've been presented arguments by the party to reserve.
You were in the Navy?
Yes, Senator.
Do you think the Navy is systemically racist?
Senator, I've served with people in the Navy from all different backgrounds.
Yes, sir, but as an institution, do you think the Navy is systemically racist?
I think our armed forces were one of the first institutions in this country that were desegregated and allowed for people from all backgrounds to serve their country and better their lives. I don't necessarily understand what that term means to everyone, but I don't.
I think it's a pretty straightforward.
I don't think today the
Is it
Navy I'm serving in is systemically racist.
Okay. That's all I wanted to know. Judge. Thank you, Mr. Chairman. Judge Casaby. I'm looking at an order you issued as a magistrate judge here requiring the use of pronouns in your court. Do you require the use of pronouns, the declaration of one's pronouns in your court?
Senator, that may be referring to perhaps a trial management order or a scheduling order of some kind?
Yeah. No, it's a statement. You issued it. Here it is.
It's an invitation for people to identify their pronouns and or their honorifics.
Well, I'm looking at your requirement that you issued to all people in your court. You say, quote, when you introduce yourself in a meeting, you should say, my name is Judge Blank and my pronouns are blank. Is that right?
Senator, those were not requirements or rules. Those were suggestions and
They were suggestions.
Those were suggestions and invitations for people to use.
And you also, in your directive, you say, quote, I'd like counsel to introduce themselves giving your full name and your honorific, such as Ms., MS period, Mix, or Mr., not Mrs. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., MS period, Mix, or Mr. End quote. Is that right?
Senator, it's not a directive. Again, it's an invitation for people to introduce themselves.
Invitation. Yeah. Okay. All right. I'm looking at an article from the Oregon State Bar Bulletin from May of 2021. And I want to read one of your quotes. Quote, we have to set aside conventional ideas of proof. Let me say that again. We have to set aside conventional ideas of proof, you said, when we are dealing with the personal and interpersonal work of equity, division, and inclusion. As a judge, I can appreciate the challenge of employing a different mode for understanding truth than that which most lawyers are accustomed to in our work, end quote. Did you write that?
That is a quote from that article.
So when we're dealing with equity, diversity, and inclusion, we should set aside conventional ideas of proof. Is that right?
In the larger context of interpersonal and personal relationships, the idea of being able to have a conversation with somebody.
Yeah, but you didn't talk about a conversation. You said proof.
It's in the context of having a conversation with somebody about the issue of their background and their experience.
So when the issue is equity, diversity, or inclusion, we should have a different set of proof. Is that right?
When it comes to the space in which people have interpersonal relationships with one another, the idea of respecting and dignifying each other with their experiences is an important part of...
So all issues have one set of proof, which has been handed down by our state Supreme Courts, our U.S. Supreme Court, except you think we ought to have a different set of proof when equity, diversity, and inclusion are at issue. Is that right?
In all of my years on the bench, Senator, I have applied the law, the rules of evidence, the case precedent.
Let me move on. I'm looking at the notes you gave us from a speech you made in February 7, 2020. It's entitled Speech Reflections on Equity and Privilege to the Oregon Blacks in Government. You wrote, quote, "White, male, straight people allow privilege to remain in place," close quote. Did you say that? Did you write that?
Without looking at the specific speech
here. You turned it in.
Well, if that's on the piece of paper, Senator, then I have no reason to disagree.
You also wrote, quote, "Privilege is incredibly similar to narcissistic personality disorder," close quote. Did you write that?
Without looking at everything in the context of that statement, it appears correct.
Okay. You wrote, quote, "The identity of Muslims also need to be normalized in a country that is so deeply Islamophobic." Did you write that?
Senator, I did. And what I'd also like to clarify is that in the context of my work on the bench, I have treated everybody equally without regard to their background.
Sorry, I just want to get through this. I'm going to run out of time. You also wrote, quote, "I am disappointed about the way in which the founding fathers of this country perpetuated inequity," close quote. Did you write that?
In the context of the issue of slavery, that was something that I'd been considering.
In your notes you gave us from a speech on May 17, 2023, "Does race matter?" You said, quote, "Does race matter? Hell yes," close quote. You know that T-shirt at the Saturday markets, the one that says something like "Love, see no color," and it has all the colors of the rainbow all over it, and it's like a tie-dye shirt. Well, the first time I saw it, I said, how sweet. Then I got angry. If love doesn't see color, then I don't have allies, close quote. Did you say that?
Yes, and that was to explain that the work of equity is to help understand where people are coming from, not to ignore who they are.
And you also... Yeah, no, I'm sorry. Can I have 30 more seconds? Judge, you seem to be obsessed with race and sexuality. I mean, you even go so far as to say that when race and sexuality and diversity and inclusion are at issue, we need a separate standard of proof in the United States federal judiciary. How are litigants going to be able to trust you?
Senator, that's not what I've said. There is no different standard.
It is bigger than Dallas. I read it to you.
When you look
turned in these documents. I didn't go looking for them.
When
you seem proud of it.
As anyone who reviews my record on the bench,
I have
thousands of cases.
I'm going to let you finish responding, and your time has expired, but go ahead.
The rule of law is an absolute for me. The work that I have done on the bench over the last 16 years.
That's not what you say.
The work that I've done on the bench.
But that's not what you say.
Judge, finish your sentence.
The work that I've done on the bench in ruling over all the people's cases that have appeared in front of me from all backgrounds, of all faiths, you'll find that I have upheld the rule of law and upheld the precedent of our Constitution and our Supreme Court and the Ninth Circuit.
Well, if the chairman would give me time, I could go through the cases and prove that that's not the case.
Senator
I just
Kennedy.
don't see how you can be a fair-minded judge.
Senator Booker.
Thank you very much.
Senator Padilla.
Mr. A-Frame, how are you?
Good, Senator. How are you?
I'm well. What is rent control?
As I understand rent control, it's some cities may have laws that limit the ability of landlords to raise rent, but it's not something I'm that familiar with.
Okay. Well, why isn't that a taking that merits compensation from government?
I don't know whether that's been litigated or how that's been resolved. I have never dealt with rent control.
Well, I want to understand what you think about it, how you think. Why isn't it a taking? I mean, your government is taking money from the private owner of an apartment. Why isn't that a taking? Just like if they took his property to build a highway.
So I'm not well-versed enough in takings to give you a definitive answer, but I'll give you what I know about takings. And
No, tell me what you think. Tell
So,
me how you would analyze that.
I would be looking at the precedents that say to what extent can government regulation be permitted.
Suppose there are no precedents. I know we'll stipulate you would look at precedents.
But
I want to know how you would analyze that case.
Well, the question is, what can the government do as far as regulation where there's still value in the property, but maybe not the maximum, and does that constitute a taking? That's what I'd have to study. I don't know the answer about that.
What you think about it? How would you analyze it?
Well, from what I know about,
What are the competing interests?
well, the competing interests are the government's interest in housing, I would think, on one side, the property owner's interest in making the maximum amount of money on the other.
Well, why couldn't the government, it has a legitimate interest to help poor people. Why couldn't the government accomplish that by just allocating some tax money to housing subsidies? And then you don't have to take somebody's private property.
That would be a policy decision, another way to try to get at that end. You're asking me whether it's a taking.
Yeah,
And I think that I am not sure that a limit on how much you can make constitute a taking, but I don't know that for sure. I would need to think about that and study that.
Well, aside from if you were back in private practice, how would you analyze that? How would you reach a decision?
Again,
Please don't tell me you go look at precedent, because
Well,
you're not going to find much.
I know that there are cases about regulation that limits the value of property. And I believe that those cases say, unless the property is basically brought down to no value or very little value, it's not a taking. That's my memory.
No,
and that
that's
would be
not
relevant.
accurate. That's
but
not
I
accurate.
could be wrong about that.
You can have a highway come through and take part of your property, which
Right.
diminishes the value, but you've still got to compensate the landowner, and you've got to compensate the landowner for consequential damages as well. That's clearly a taking. Why is rent control any different, Counselor?
Senator,
Achieve a government purpose in a less discriminatory way? Why isn't this open and shut?
Well, Senator, without doing more work on it, I mean, I tried to tell you what I would think about it, but I'm also telling you I don't know necessarily how it would come out, and I would need to read and think about it more. But I would think about the government interest, understanding that there is a loss to the owner of the property, and figure out how those interact.
Okay, what's the new rule about how flexible an employer has to be if an employee asks for an accommodation because of a religious belief?
There has to be, the employer has to suffer a substantial hardship, which is a change in the law. The law was more, gave employers more flexibility in that area, and there was, I think the cases DeJoy from last term made that more difficult for employers, raised the burden on them.
Okay, fair enough. You will faithfully follow precedent, is that right?
Yes, Senator, I will do my very best to do that, yes.
Would you have followed the Dred Scott case?
As a lower level judge?
Yeah.
I mean,
It's a yes or no.
I think that, Senator, I mean, there's a fidelity of lower court judges, and hopefully our Supreme Court would make the right decision
You
there.
have followed the Dred Scott case.
As a lower court judge, I think you have no choice, but you can write that the Supreme Court should do something about that, and I would have.
Would you have followed Plessy v. Ferguson?
It's the same answer. You have to. Agostini versus Felton said lower court judges must follow Supreme Court
Why
precedent.
wouldn't you quit first?
Well, I guess I hadn't thought of that option, Senator, but I would certainly make my voice heard, but I would have to follow the
Dred
precedent.
Scott was an immoral decision, do you?
Yes, Senator.
Okay, why wouldn't you quit?
Perhaps I would. I hadn't thought about it like that, Senator. I don't know. I hadn't thought about that.
Okay.
But I would make my voice heard. But I do want to say that in a vertical court of a judicial system, it is critical that middle-level judges do their best to follow precedent.
Thank you, Mr. Chairman.
Thank you, Senator Kennedy. Senator Padilla. Kennedy.
Thank you, Mr. Chairman. I just feel like I need to ask this question. Mr. Fonzone, when you advised the companies referenced, Huawei and others, you were at Sidley?
Yes, that's right, sir.
And when a client comes to Sidley, you have to fill out a form that says, here's my client name, here's my mailing address for business purposes, and here are my political beliefs. Is that the way it works?
There's definitely a client intake process. I don't remember all the particulars of it.
I mean, big law it's kind of like who can pay the freight, right?
That's an aspect of the intake process, I'm sure.
I understand. Professor, I'm looking at a letter dated March 16, 2020. It's a letter to Governor Lamont in Connecticut. The title of it is Urgent Action Needed to Protect Individuals in Connecticut's Prisons and Jails from Coronavirus 19 Pandemic. Did you sign that letter?
So I don't recall sitting here today, Senator.
Here's your signature. Here it is back here. Why didn't you turn this over to us when you were asked to submit documents?
So, Senator, I made every effort to search for everything that I had ever signed. That's not a letter I remember, but I will certainly take a look at that. And
well, we found it just with a search on the internet.
So I apologize, Senator. I apologize.
In your letter to the governor, here's what you say. As they stand, prisons and jails are detrimental to public health and human rights and disproportionately harm marginalized communities, including Black, Brown, Indigenous, and other communities of color, immigrants, people with mental illness, people with disabilities, people in the LGBTQ plus community, people who use drugs, people engaged in sex work and street economies, and people experiencing houselessness and poverty. So if you believe that about our prisons, how are you going to ever send somebody to prison?
So, Senator, I will need to take a look at that letter, and I apologize that that's not something I found to hand to this committee.
You're not denying you said that.
I do need to see the letter to see the context, because again, it's not something I remember adding my name to. I can assure you, right, Senator.
And you also say, first, you call on Governor Lamont to release everybody in jail. Is that right? Because of the coronavirus?
So again, Senator, I would need to see that letter in front of me. It certainly was not.
You can find it just put your name into Google. You'll find it in about 3 nanoseconds.
I will, Senator. I can assure you that
You said in your letter, Professor, we call on Governor Lamont, state of Connecticut, and all Connecticut jurisdictions to immediate release to the maximum extent possible people incarcerated pre-trial and post-conviction. And then you go on to say, talking once again about our jails, the global COVID-19 pandemic is throwing into sharp relief the untenable state of our penal system and the need for sustained action to shrink its scale, shrink its size, and shrink its scope. You sound here like the district attorney in San Francisco. If you believe that, how are you going to ever sentence anybody to jail, Professor?
I can assure you, Senator, that I understand the role of the judge and that I can assure you prison time is an appropriate sentence in many cases.
That's not what you say here to the governor. You wrote the governor. This isn't some DoorDash delivery guy. You wrote the governor of your state 3 years ago.
So again, Senator,
in law school.
So again, Senator, I would need to look at the letter. It sounds like it was written at the height of the pandemic where governors were looking for.
You also wrote the governor, you said people over the age of 55 are at the greatest risk for COVID-19, but also pose the least public safety risk to our communities. People in this age group can and should be released immediately to mitigate the spread of COVID-19. You think the governor just, if you're over the age of 55, he should let everybody go?
No, Senator, that's not a position.
That's what you said.
Okay.
Here it is, biggest house.
Again, Senator, I will look at that letter. I can assure you that.
Find it on Google, Professor. You also say Governor Lamont should issue an executive order to direct the state's attorney offices and law enforcement entities, including the town and city police departments, and any federal law enforcement entity operating within the state to immediately cease adding to the incarcerated prison population given the high risk of infection posed by the population increase. You asked the governors to tell every law enforcement official in the state to stop arresting people and putting them in jail, didn't you?
So again, Senator, I have to look at that letter. I do think there were modifications that the governors were making around the country to respond to the pandemic.
You also had an opinion in your letter about, can I have another 30 seconds, Mr. You had an opinion in your letter about immigration. You said immigration detention poses the same health risk to jails and prisons, and Connecticut law enforcement must stop feeding people into the unsafe and inhumane immigration detention system. Then you say Governor Lamont should release all individuals currently in state custody who are awaiting transfer to ICE custody, and the governor should declare a moratorium on all such future transfers. How, if somebody is in our country illegally and commits a crime, are you going to put them in jail if you believe this about immigration?
Senator, I can assure you, were I so fortunate to be confirmed, I would treat crimes seriously.
That's not what this letter says, Professor, and it was 3 years ago. It wasn't when you were in law school, and you didn't turn it over to us. We had to find it on our own.
Senator, the chair has been generous in time. I think you've had.
Mr. Chairman.
Senator Kennedy.
Mr. Chairman, I'm not going to repeat what my colleague, Senator Cruz, said about Judge Casabai, but he's not qualified to be on the federal bench. And everybody on this in this hearing today knows that. You heard the same testimony I heard. He's entitled to his beliefs. Look, about 90% of my personal philosophy is don't hurt somebody unless you have to defend yourself. Don't steal other people's stuff, and leave me alone. If you want to use different pronouns, that is your business. I may not agree, I may not do it, but that's your business. This is America, and you're free to do that. But this judge used his authority to require litigants in his courtroom to do what he thinks is politically correct. And he did that as a magistrate judge. And he'll do it as a federal district judge, and you know it. Once again, I don't care what his political beliefs are, but he has no right as a sitting judge to direct in writing litigants in his courtroom to stand up and introduce themselves by saying, "My name is John Kennedy. My preferred pronouns are." Now, the judge said in his testimony that was voluntary. That's not true. I've read the order. And he said, but it's voluntary. It's voluntary. Right. I'm a litigant in his courtroom paying a lawyer $400 an hour to try to get my case resolved. And the man on the bench who's going to decide my case tells me to stand up and announce my pronoun. That's not voluntary. That's oppressive. And that alone, forget his writings, which Senator Cruz went through very eloquently. That alone tells me that he cannot exercise power maturely. If I could vote no twice, I would. And on this final point, when President Trump nominated people that weren't qualified to be on the federal bench, we killed those nominations. And several people on your side of the aisle, my Democratic colleagues, and on our side of the aisle did it. By my count, we killed 5 of them. Dead as fried chicken. And we didn't do it behind closed doors. We did it here in the committee. We demonstrated they weren't qualified. Now, here's your chance. This man is not qualified to exercise power as a federal judge. It's bad enough that he's a magistrate. Thank you, Mr. Chairman.
Judge Kasabai has responded to the questions that have been raised on this topic, and I'd like to read his response. Let me state unequivocally, as I did during my hearing, I am not and never have been a Marxist. I have never espoused nor subscribed to Marxist theories. Rather, I've been an active participant in and beneficiary of the American capitalist system, as is clear from my own holdings of private property and securities, as detailed in the statement of net worth provided to this committee. And there's more, if you wish to read it. Let me also note that he has served for 16 years on the state and federal bench and as a neutral appellate decision maker for 4 years on the Oregon Workers' Compensation Board. He has an ample record of service as a judge, and his philosophy is demonstrated in any rulings that he has handed down. So in defense of Judge Kasabai, I think some of the charges that are being made are wildly unsubstantiated.
Mr. Chairman, may I be heard for just 30 more seconds?
I've been very generous to
I know you have. Would you be generous one more time?
I will. Go ahead.
Thank you. Thank you. I appreciate the judge's response, but we all heard his testimony, and we all have read his record. And sometimes people don't tell the truth in their responses. I'm not calling the man a liar. I'm just saying, who are you going to believe? His written responses, probably crafted by the White House lawyers, or his testimony in committee? And I think what we're going to see going forward is more of these types of exchanges going on here today. When somebody's qualified to be on the federal bench, by God, I will stand up. I don't care what party they are. I was the lone Republican vote to confirm a nominee from Tennessee. I'm almost done, Mr. Chairman.
Almost
the
30
lone
seconds.
Republican vote. But from now on, if we're going to play it like this, we're going to have a debate on all of these nominees and talk about their testimony in committee and who was forthcoming and who wasn't. Thank you, Mr. Chairman. You've been very kind, and I appreciate the extra time.
You're welcome. Unfortunately, one of our members has had to go to the floor, and we don't know when he's going to return, and I can't ask the committee to sit and wait. We'll reconsider these 2 nominations next week. The committee stands adjourned. Kennedy.
Thank you, Mr. Chairman. I just feel like I need to ask this question. Mr. Fonzone, when you advised the companies referenced, Huawei and others, you were at Sidley?
Yes, that's right, sir.
And when a client comes to Sidley, you have to fill out a form that says, you know, here's my client name, here's my mailing address for business purposes, and here are my political beliefs. Is that the way it works?
There's definitely a client intake process. I don't remember all the particulars of it.
I mean, big law it's kind of like who can pay the freight, right?
That's an aspect of the intake process, I'm sure.
I understand. Mr. Chairman.
Senator Kennedy.
Mr. Chairman, I'm not sure I can do better than Senator Cotton, and I'll try not to repeat what he just said. Even a cursory examination of Mr. Casabai's record and his testimony before this committee, I think demonstrates to most fair-minded Americans that he is from the loon wing of the American bar. Now, that is his right as an American. You're not free if you can't express yourself. You're not free if you can't say what's on your mind. But it is clear to me, based once again on an examination of his record and his testimony, that Mr. Casabai is not qualified to be a federal judge because of his partiality. And I believe that his decisions will be filtered through his own political, social, and economic beliefs. Senator Cotton was very eloquent in giving you some specific examples. I want to give you one more. Mr. Casabai is a magistrate. He issued an order, not an oral directive, but an order to all employees in his court, to all witnesses in his court, and to all lawyers in his court, that they address the court in a specific way and that they include their preference for pronouns, which, as we all know, is a reflection of one's thoughts about gender. This is a copy of the order. I think everyone has a copy. This is what his written order directs, for example, to his criminal docket clerk. Quote, I'm quoting the order, not the suggestion, the order. Before calling the first case, give the general instruction, quote within quote, I'd like counsel to introduce themselves, giving me your full name and your honorific, such as Ms., Mix, or Mr. Not Mrs., not Miss. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., Mix, or Mr. Mr. Casabai says this is voluntary. That's not true, and he knows it. He intentionally misled this committee. He uses directives like, please be sure to give the honorific. You can read the document for yourself. I would feel the same way if Mr. Casaby directed everyone in his court, and frankly, I could see him doing it, to stand up and give me your name and tell me about your race. I would feel the same way if Mr. Casaby issued a directive to tell everyone in his courtroom, you have to give your name and your religion. And you have to give me your feelings about Israel. And you have to give me your details about your ethnicity. And you have to give me details about your sexuality. All of the things that bring the issue of partiality to the forefront, Mr. President. I'm appalled that President Biden nominated this gentleman. Now, again, when I asked Mr. Casaby in committee, he said, oh, this is voluntary. Well, it's not. Here's the document. You can read it for yourself. And if he's confirmed, there will probably be more directives about how litigants and their lawyers and his court personnel have to address the court. But imagine, let's assume it is voluntary. Imagine you're a litigant whose property or liberty is at stake. And the man in front of you who is going to decide your fate tells you that he wants you to give your personal pronouns. And you don't want to do that. You'd rather not participate in that. You don't mind if others do it, but you personally don't want to do it. You've got to make a decision. Do I stick with my beliefs, or do I try to curry favor with this judge who's going to decide my freedom or make a decision about my freedom or my property? That is the classic definition of bias. And that, Mr. Chairman, will be why I'll be voting no on Mr. Casaby. I want to emphasize again, I'm not criticizing his beliefs. He's entitled to those beliefs. If you want to be a member of the loon wing of the Bar Association, that is your right as an American. But it doesn't give you the right to bring that bias to the federal bench. Thank you for the time, Mr. Chairman.
Thank you, Senator Kennedy. Unfavorably reporting the nomination of Mustafa Casaby. Senator Lee is recognized.
Thank you, Mr. Chairman. Congratulations to each of you. Ms. Hill, what is collateral estoppel?
Collateral estoppel. I think collateral estoppel, well, Senator, I will say that my 20 years of practice has primarily been dealing with issues relating to criminal law or relating to other areas of the law.
Yes,
and
if you don't know, just tell me.
I certainly do know collateral estoppel. I'm finding that the bright lights of the moment are making it hard for me to recall it.
Okay, so you don't recall it. Okay. What is the amount in controversy requirement?
The amount in controversy requirement is $75,000. It typically governs, in many cases, almost any case in diversity jurisdiction in the federal courts.
Okay.
And in certain other.
What does the 13th Amendment to the Constitution do?
It outlaws slavery.
What does the 7th Amendment do?
It ensures that all civil jury trials, that all civil cases in the United States are done by jury trial. That you have a right to a jury trial in a civil case.
Okay. What is the difference between a stay order and an injunction?
A stay order would prohibit, an injunction would restrain the parties from taking action. A stay order, I'm not sure that I actually can give you the.
Okay.
That.
Tell me about, you'll see a lot of this in federal court. Tell me about the multi-district litigation statute.
So I'm not extremely familiar with the multi-district litigation. I do know that multi-district litigation is often consolidated into a particular court. So all of the cases involving a particular type of issue, if there is a multi-district litigation, those will all be referred to one court and one judge who will then oversee the MDL. But I will confess I'm not super familiar with all the ins and outs of that.
Okay, what kind of constitutional claims are subject to intermediate judicial scrutiny?
Cases involving certain types of classes, such as gender or illegitimacy, are subject to intermediate scrutiny. Some types of speech, like commercial speech, would be subject to intermediate scrutiny.
Okay. Tell me what a 12B6 motion is.
It's a motion to dismiss a claim, or a motion to dismiss an issue for failure to state a claim.
Okay. And what's the standard for granting a summary judgment in federal court?
It says that there are no issues of material fact, and that the issue can therefore be decided as a matter of law.
Okay. What's the standard for deciding whether a particular punishment is cruel and unusual under the Eighth Amendment?
So the particular standard the court has said, and I cannot recall the case, but it says that you have to look at not only whether it is would be shocking to the individuals at the time that it was written, so it's not purely a historical review, as some of them are purely historical, but also you have to look at how it has changed, how those values have changed with time. It's one of those cases, circumstances where the court says it's appropriate to look at how values have changed with time.
Well, our right against cruel and unusual punishment is a fundamental right, is it not?
It is.
Okay. How do you square what you just told me about the Eighth Amendment with the case after case after case by the U.S. Supreme Court that says the definition of a fundamental right is one that's explicitly stated in the Constitution or deeply rooted in our history and tradition?
Yeah, I think that it is. I think it is deeply rooted in our history and tradition.
Yeah, but certain forms of punishment are not. If a form of punishment, it existed at the time of our founding, and it's deeply rooted in our history and tradition, you telling me that makes it automatically constitutional today? I thought you just told me.
No, I'm certainly not saying that. I'm not. What I say about it is really quite irrelevant, but the Supreme Court has said we look at it with a view to the changing values on these
why
issues.
The difference? I thought
they're
both fundamental rights. Why the difference?
You know, I think that's a question that the Supreme Court's going to have to answer, whether or not they have.
I think it has. I'm just asking if you know.
I think I've answered the question to the best of my ability, Senator.
Okay. Thank you all.
Senator Hawley, going to return? No. I think that all the senators have appeared who are going to question today. Ms. Hill, I congratulate you on surviving the John Kennedy 6-minute bar exam.
My contracts teacher is going to be appalled, and I'm going to have to live with that, Senator, but thank you, Chair. Thank you.
If you promise to spare Ms. Hill, I'll...
Did the White House give any of you any written materials to use to prepare?
They gave...
Or digital materials?
They gave us, questions, previous questions that had been asked by the panel.
And answers?
I think we had to go find the answers ourselves. I think we had to go watch the various committee
May I
meetings.
have a copy of that?
I don't have one, but I'm sure that it is literally just a list of questions.
I don't have a copy.
I don't have any of the
Would you send me a copy? I'm easy to find. Would you send me a copy, Ms. Hill?
I will.
Okay. Would you each send me a copy?
Yes,
so I can
Senator.
compare and make sure they're all the same. Okay. Thank you.
Senator, can we have a copy of your list of questions to share with other members?
I'll even give you the answer.
It's like a bar. It's like a bar review course.
Yes.
Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being